Hey everybody, my name is Shaunak Darup. I'm a civil litigator and a partner at Orange Davis Law in San Francisco. And today I'm going to talk to you about President Biden's proposed "No one is above the law" amendment to the Constitution. I'm going to talk about the people who are above the law, at least in the eyes of the law, talk about immunities, and I'm going to talk about what it takes to actually get a constitutional amendment pushed through. And all of this is going to be in the backdrop of the Trump versus United States decision that confers presidents with absolute immunity in certain cases. So for those of you who don't know, President Biden proposed three sweeping changes that are labeled as Supreme Court reform. And the first change is a constitutional amendment he has proposed called "No one is above the law" amendment. The amendment would state the Constitution does not confer any immunity from federal criminal indictment, trial, conviction, or sentencing by virtue of previously serving as the president. Now, that's not really Supreme Court reform, but it is a response to a decision by the Supreme Court this term, Trump versus the United States. And that was the decision in which the Supreme Court held President Trump did have some level of presidential immunity from criminal prosecution. And we'll get into the specifics of that. But first, I'm going to talk about the name. No one is above the law. The reality is there are plenty of people who are above the law, at least in practice. Usually when certain people are acting in official roles, there is immunity, either by virtue of the roles themselves or the conduct of those individuals as a part of that role. Immunity by virtue of an official role. A great example is diplomatic immunity. Diplomatic immunity usually arises out of treaties between two countries. A person who is a diplomat in a foreign country can be immune from arrest, from prosecution, from civil liability, just by the fact that they are a diplomat of a foreign country. The purpose behind diplomatic immunity is that countries want their diplomats to be able to freely go to other countries without the fear of retribution or pretextual arrests or lawsuits. Diplomatic immunity is a way to avoid shooting the messenger. It keeps diplomats safe, and it keeps dialogue between countries open, and diplomatic immunity generally serves everybody well by keeping the peace between countries. Unless the diplomat does something that causes injury to somebody else, can't be prosecuted, can't be held liable, and there have been cases where this has happened. And the family of the victim can't get appropriate compensation or redress because of diplomatic immunity. Like all immunities, diplomatic immunity is a weighing of two really important considerations. On one hand, you have this larger policy need to shield the diplomats from potential bad actors in foreign countries in order to facilitate a greater peace. On the other hand, you have fairness and justice on the micro scale to the individual, which necessarily take a hit in favor of these more high-level policy considerations. In addition to immunities that exist by virtue of your official role, there are immunities that exist by virtue of conduct you engage in an official role. So, for example, legislative immunities. A member of Congress can't be prosecuted, can't be sued for things they say on the floor of the House or the Senate.
If you want to run your mouth, we can be two consenting adults. We can finish it here.
Okay, that's fine. Perfect.
You want to do it now?
I'd love to do it right now.
Well, stand your butt up then.
You stand your butt up.
Oh, hold on.
Big
Oh,
guy.
oh, stop it.
Is that your
All right.
solution, every problem?
It's the speech and debate clause of the Constitution. They are immune from prosecution or civil liability if they are acting in the course of their duties as a member of Congress. There's a much misquoted part of that speech and debate clause in the Constitution that essentially says members of Congress can't be arrested while on their way to or in a session, except for in cases where it's treason or felony or a disturbance of the peace. The reason that was put into the Constitution was that way back when the Constitution was created, it was actually pretty common for people to get arrested as a part of civil suits, not just criminal suits, but civil suits. For example, if you owed a debt to somebody, you could get arrested and go into a debtor's prison. That doesn't really happen anymore, but it did back then. And the founders wanted to avoid the president's agents being able to arrest a member of Congress on the way to an important vote to prevent that person from carrying out their duties, to prevent the executive branch from having too much power over how the legislative branch did its work for the running of the country. Everything in the Constitution should be viewed as a pushback against a monarchy the founders had fought to get out from under. But that clause doesn't mean that members of Congress can't be arrested or detained on the way to a vote if they're committing some criminal act. Actually, a member of Congress was detained because he tried to bring in a gun through TSA on the way to a vote. And no, that was not actually protected conduct under the speech and debate clause. Another example of immunity by virtue of official act or official conduct is judicial immunity. A judge can't be prosecuted for ruling on the law, can't be held civilly liable for reaching a decision as a part of their judicial duties. This makes sense. You don't want an independent judiciary that is then afraid of being prosecuted by the executive branch or private individuals for carrying out their duties in adjudicating the law. Now, these immunities come from a good place. You don't want our congressional representatives to be arrested or sued for having a vigorous debate on the floor of the House or Senate. You don't want judges to be arrested for making decisions that the executive branch is not happy with. And you certainly don't want diplomats getting arrested or prosecuted or put in jail or sued as a pretext or a proxy for hostilities between two sovereign nations. So this all leads up to presidential immunity. If a president is constantly worried about whether or not their actions could be basis for prosecution, then the president is going to be more reserved in the actions they take, is not going to take bold actions that might ultimately result in public good, but for fear of future prosecution. At least that's what the Supreme Court reasoned in its decision in Trump versus the United States. Former President Trump was indicted in connection with January 6th, and the allegations included his pressuring of his attorney general, his communications with Vice President Mike Pence about not certifying the election, and his communications about putting these other electors, these false electors, in place towards not certifying an election in which President Biden won. The court talked about presidential immunity in three spheres. The first is immunity for acts that are within the core powers of the presidency. This is what the court referred to as the conclusive and preclusive powers of the president. Basically, the powers that lie solely with the president and aren't shared with Congress or the judiciary. So these are powers like the veto power, the pardon power. One of these core powers, the court found, was the management of the executive branch and the ability to fire an attorney general. That's something that's held solely within the power of the presidency. Nobody else holds that power. And so pressuring an attorney general to do or not do something, the court said, falls within the president's core powers. The second sphere is official acts. So these are powers of the presidency that aren't the core powers, that aren't exclusive to the presidency, but they're powers that are up to the outer perimeter of what's within the scope of the presidency. So the court held that when President Trump told Vice President Pence not to certify the election, that communication was an official act. That conversations between the president and the vice president about the certifying of elections falls within the scope of the president's duties, and therefore there is presumptive immunity. So not absolute immunity like with the core powers, but presumptive immunity, which means that the prosecutors who are prosecuting the former president have to rebut that presumption, have to show that prosecuting the president for that isn't going to essentially hamper the ability of the government to function, isn't going to create a chill in the executive branch that would prevent a president from doing certain things that are within that president's power. And the third bucket was unofficial acts, for which there's no immunity. Acts the president takes outside their role as president. And so these three buckets, core powers, official acts, unofficial acts, absolute immunity, presumptive immunity, and no immunity. Now, the Supreme Court didn't decide that President Trump was immune from all of the allegations against him. It remanded to the district court, where they're going to have to figure out whether the presumption of immunity for the official acts can be rebutted, and whether a bunch of the acts and the allegations are official or unofficial acts. And it gave the courts a kind of rubric that is a little unclear, and specified that courts, when you're figuring out whether something is an official act or an unofficial act, you can't look at intent. You have to sort of look at these in a vacuum and decide, are these acts within the outer perimeter of a president's scope of duties, or are they not? I'm not particularly upset about the reasoning of the immunities in this decision. I'm more concerned about the line drawing the court engaged in to determine what was an official or unofficial act. Because on balance, these buckets of immunities do make sense. Presidents should be immune for exercising their core constitutional powers. Presidents should have some level of immunity for official acts. Just like judges do, just like legislators do, they should be able to do their job without fear of prosecution. But I don't agree with the court's line drawing on what was and wasn't an official act, because unlike the Supreme Court's decision, I tend to think that intent is actually the keystone in determining what's an official and an unofficial act, because in almost every other aspect of the law, intent matters. There is a reason that members of Congress aren't immune from bribery. If we were looking at immunities in a way that is agnostic to intent, where intent doesn't matter, you could say that a member of Congress who takes a bribe to vote a certain way shouldn't be held liable, should be immune from prosecution, because you can't prosecute them for voting. Because prosecuting someone for voting a certain way is against the speech and debate clause of the Constitution. But it's not really about the way they voted, it's about why they voted that way. Because they were paid to do it. That's bribery. And members of Congress aren't immune from bribery. This amendment is a direct response to this ruling. It aims to amend the Constitution to very specifically say that former presidents aren't immune from criminal prosecution just because they were the president at the time they committed those acts. I'm unsure that the plain language of this amendment actually does anything to affect the Trump versus United States ruling, because the amendment reads, the Constitution does not confer immunity by virtue of previously serving as the president. And yet I don't read Trump versus United States to confer immunity by virtue of previously serving as the president. I read it to confer immunity by virtue of acting in the scope of the president's official duties. I think that the Supreme Court engaged in line drawing in determining what was and wasn't an official act in a way that far broadly defines official acts than I'm comfortable with. But I don't think this amendment actually changes that. In any case, it's sort of a moot point, because I don't think there's a way this amendment can get passed, because it is super difficult to amend the Constitution. Amending the Constitution is a two-step process: the proposal and the ratification. There are two ways to put an amendment to the Constitution on the table. You can do it through Congress, or you can do it through a constitutional convention. In Congress, it has to have 2/3 of the vote of both houses. So the House of Representatives has to vote by a 2/3 majority to bring this amendment to the table. Then the Senate has to vote by a 2/3 majority to bring this amendment to the table. And then it is proposed. Alternatively, 2/3 of the state legislatures, so the legislatures of 34 states, all have to agree and call for a constitutional convention. That's already a big bar just to get an amendment proposed, put on the table. Once it's on the table, it has to be ratified. There are two ways to ratify an amendment. The first is by approval of 3/4 of the state's legislatures. So 38 out of the 50 states, their legislatures have to approve the amendment, and then it'll pass and be an amendment to the Constitution. Alternatively, there's a process in each state's constitution by which the state can convene a constitutional convention within the state itself. In this political climate, it is highly unlikely that a constitutional amendment gets put through. This issue really is going to get resolved over years, decades of judicial decisions and jurisprudence. And it's going to be very interesting because this really is a bipartisan issue. Yes, right now it's in the context of President Trump, but the question of potentially unfettered immunity in the executive is something of great concern to the party that's not in power, and that always changes. So immunities generally have good reasons. The Supreme Court's decision in Trump versus US, I think, wasn't way off base in how it categorized the types of immunities that a former president can have. I think it was way off base in the line drawing. I think where it veered off course was how it defined what constitute official acts, what constitute acts within the core power. What I'm heartened by is that the majority of that line drawing is still left to the district court, is still left to the facts. And even if something is determined to be an official act, the immunity is only presumptive, which means a good prosecutor with good facts can overcome that presumption. Thanks for watching this video. If you liked it, if you agreed with me, drop a comment down. If you didn't like it, if you disagreed with me, drop a comment down. I have no immunity against angry comments, as my last few videos have proven to me. All right, I'll see you all next time and have a great day.